An open letter written by the Veri Community addressing the similarities in the SEC versus Debtbox case and that of Reggie Middleton, founder of DeFi, US 111-96566B2. The Honorable James David Vance, United States Senator for Ohio, United States Senate, Washington, D.C. 20510. Dear Senator Vance, regarding Securities and Exchange Commission, SEC versus Reggie Middleton, Veritasium Inc., and Veritasium LLC, the defendants, Case 1:19-CV-04625. The above case was one of the earliest enforcement proceedings taken by the SEC against cryptocurrency enterprises back in 2019, and sadly the defendants were railroaded into a final consent judgment without admitting or denying the allegations of the complaint. The above case is on all fours with the Debtbox case referred in the February 7, 2024 letter to SEC Chair Gary Gensler, signed by yourself, Senator James Vance, along with Senators Tom Tillis, Bill Hagerty, Katie Boyd Britt, and Cynthia Loomis. The primary difference between the two is that this case involves foundational technology and associated patents that control much of the new global paradigm in value transfer, essentially the next evolution of money. The U.S. currently rests atop the mantle as global reserve currency issuer, a position that is literally threatened by the actions of the overzealous and less than ethical SEC. This revolutionary technology was invented by an American, unjustly crippled by the SEC, an agency whose mandate is to strengthen America, not weaken it. Mr. Middleton's inventions are currently in use or plan to be in use by 90% of the world's central banks as they roll out their next generation of sovereign currencies. Background. Very briefly, the defendants conducted an initial coin offering, ICO, during April-May 2017, wherein Veritasium LLC sold Veri utility tokens, representing the prepayment of goods and services being developed and, in part, provided by the defendants. Within weeks, the SEC commenced a 2-year investigation, pre-Wells process, whereby, and at considerable expense, both in terms of time and money, $1.3 million, the defendants provided over 1 million pages in response to subpoenas, including Mr. Middleton giving sworn testimony on 5 different full-day sessions. The defendants cooperated fully with the investigation, even though it put the fledgling startup under severe financial strain. During this period, the defendants developed the second iteration of a digital platform to facilitate peer-to-peer exchanges, without the need for centralized middlemen, counterparty risk-free, of a wide range of assets. This was an early implementation of decentralized finance, or DeFi, which currently underpins what nearly every money center, bank, and asset manager is moving towards today. By first quarter of 2018, VADR, Veritasium Autonomous Dynamic Interactive Research, was operational and in beta testing by outside users. On March 20, 2018, Mr. Middleton and his staff gave a live demonstration of the system to SEC staff members, who attended in person in New York and virtually from Washington, D.C. At the conclusion of the presentation, the SEC staff lead praised Mr. Middleton on the functionality of the system, stating they'd never seen the technology work at this level before, then instructed him to shut it down the following day. On July 30, 2019, the SEC issued a Wells notice making a preliminary determination to recommend enforcement actions against the defendants, whereby legal expenses, which were already quite burdensome, would increase significantly. By August 12, 2019, the SEC filed for a temporary asset freeze, restraining order, and other emergency relief against the defendants, all of which were granted by the U.S. District Court for the Eastern District of New York. The restraining order froze the defendant's business assets and accounts, with an attempt at freezing his personal accounts as well, shut down the business, and caused its Veri token to crash, rendering it almost impossible to defend against. This eliminated 25 jobs and contractors and sullied the economic situations of many Veritasium stakeholders, the majority of whom were American. More importantly, it put at extreme risk America's position as a leader and linchpin in this new technology that can realistically be characterized as the Internet of Money and Value Transfer. False and misleading representations. The SEC made materially false and misleading representations, undermining the integrity of the legal proceedings. The SEC's motion relied heavily upon their expert's declaration that alleged via legal filings and doubled down via globally available press release. Quote, Middleton recently moved a significant amount of investor assets and then dissipated a portion of those assets, transferring them to Middleton's personal account. End quote. A patently false statement among multiple others. Some of the false statements were corrected days later after the defendants had responded to the false allegations, but the damage had already been done on a global basis, as the defendants' international partners and clients started moving away. Note, this correction was not autonomous or voluntary. It was done after the defendants showed the court empirical evidence debunking the SEC's allegations. The Senator's letter to the SEC stated that, quote, it is difficult to maintain confidence that other cases are not predicated upon dubious evidence, obfuscations, or outright misrepresentations, end quote. This is such a case, to the nth degree, and to the detriment of America's position in the race to maintain its lead in the global economy. Given the unbridled power and funding the SEC has, it must be incumbent upon them to ensure that they present accurate and truthful information in any proceedings. Indeed, there must be an overriding obligation to do so, considering the devastation they can cause to legitimate businesses. In addition to scuppering a deal with the Jamaica Stock Exchange, JSE, for which there was a memorandum of understanding in place under which the defendants would, quote, sell, lease, rent, or lend its Veri tokens to the exchange, end quote, for the purposes of consulting on, advising on, and building a digital asset exchange, bracket, explicitly embedding U.S. technology in a foreign nation, which had the best performing stock market in the world, twice, end bracket. The SEC staff caused the collapse of a signed joint venture with the second largest stock exchange on the African continent, located in one of the most influential members of OPEC, with whom the defendants were planning on tokenizing their commodity exports, again embedding American technology directly in the strategic areas of global commerce and geopolitical influence. SEC staff scoffed and ridiculed Mr. Middleton, quote, self-proclaimed financial guru, end quote, referencing the aforementioned press release and legal complaint, alleging the marketing of his foundational patent applications for DeFi, decentralized finance, to be fraudulent, stating he marketed international patent applications he knew he would never be granted due to, quote, lack of novelty, end quote. The U.S. Patent Office has since granted two foundational patents, bracket US 1119656B2 and US 11895246B2, and the Japanese Patent Office granted two more, bracket JP 6813477B2 and JP 720423-1B2. The original U.S. patent grant has withstood challenges to its, quote, novelty, end quote, and validity in court, and there have been many more patents pending in numerous jurisdictions. Ironically, upon information and brief, the SEC itself uses the defendant's, quote, fraudulent, end quote, patented invention when pursuing crypto and blockchain companies. Belligerent behavior, unbecoming a U.S. agency representative, and outright threats. Paradoxically, making matters worse, the alleged, quote, security, end quote, as the SEC claimed, the Veri token, was not dealt with in the final consent judgment, rendering all Veri token holders held in some 24,000 addresses in limbo. In an effort to clarify their position and status, the Veri token holders, aka the alleged defrauded according to the SEC allegations, through counsel, sent the SEC's Corporate Finance Division a request for a, quote, non-action letter, end quote, or a NAL, electronically submitted on May 13, 2021, and their response was handled by a teleconference on June 11, 2021, between attorney Jeremy Hogan for the Veri token holders and four SEC attorneys, including Mr. George Tenrero, Mr. Mark Villardo, and Mr. Jay Ingram, and a fourth unnamed SEC attorney. What was highly unusual was the presence of a lead prosecutor in the above case, Mr. Tenrero from the Enforcement Division, who controlled the meeting. In the author's view, the mere presence of Mr. Tenrero during the teleconference was an unethical and breaches the SEC's supposed Chinese walls, not to mention the fact he led the meeting, issuing threats. The very token holders were denied the NAL, and Mr. Hogan was told to warn the said token holders that the very token was a security and could not sell, transfer, or otherwise dispose of their tokens. This was received as a not-so-veiled threat. Since then, we have had some clarity from the Honorable Judge Torres ruling in the SEC versus Ripple Labs XRP case about the sale of such, quote, securities, end quote, in the secondary market. This clarity, this author believes, was achieved in part through the submission by the very token holders of an amicus curiae brief to Judge Torres, clearly illustrating, articulating, and informing the court of what happens to the holders of this technology when the SEC is successful in collapsing the vendors of this cutting-edge technology through regulation by enforcement, versus working with American entrepreneurs to create a transparent regulatory regime. Finally, we would like to bring to your attention specific actions by SEC prosecutor Mr. George Tenrero that raise serious ethical and legal questions. Mr. Tenrero has reportedly aggressively pursued numerous Veri token holders, trying to convince them that they were victims of a Ponzi scheme and fraud, even when these individuals explicitly stated that they did not consider themselves as such. It should be noted that at one of the depositions before trial, the SEC's declarant, Mr. Michael Middleton, no relation, actually turned to the side of the defendants, stating he was not defrauded or believed he was sold an investment. Quote, I questioned Mr. Middleton about the price volatility and told him that, quote, I am a long-term investor and my plans were to hold VeriDAO for a long time, end quote. Mr. Middleton responded, among other things, quote, what concerns me is your use of the term, quote, investment, and your allegation that I advised you. I don't like that, and neither is true, end quote. Reggie Middleton then offered me a refund of my purchase. I then replied with an apology on June 11, 2017, because Mr. Middleton had not given me investment advice and declined the refund. Since 2017, I have used a few Veri to purchase research reports from VeriDAO. I still hold approximately 2,350 Veri. This behavior not only undermines the integrity of the SEC investigation, but also potentially violates multiple legal and ethical standards. We would respectfully request the Honorable Senator James Vance and the other named senators to investigate the above matter and the serious claims made in this letter, as we consider what other actions are open to the Veri token holders. Respectfully, the Veri community. This is an open letter that you can copy and paste and send to your own senator or representative. The link to this file will be in the description below.